Hello and welcome to Workplace Matters, the podcast that focuses on topics related to workplace accidents in Florida, hosted by the one and only Diana Castrillon and Henry Roman.
Hello, everyone, and welcome to the new workers' compensation series for the Broward County Bar Association that is called Workplace Matters. I'm Diana Castrillon. I'm with the firm of Powell, Jackman, Stevens, and Riccardi, and my co-host.
Hi, I'm Henry Roman. I'm with the law firm of Martinez Roman, and we're looking forward to presenting these interesting topics on Florida workers' compensation and workplace accidents.
And for our very first topic, we decided to cover something that is pretty hot right now in the state of Florida. And so we're going to be discussing a pretty critical topic in the area of workers' compensation, and that's occupational causation. And so, Henry, I'll go to you to talk a little bit about the introduction on this.
Yeah, so I guess just by way of background, right, there's three basic elements that anyone who's prosecuting a claim for workers' compensation has to meet. The initial accident, right, the coverage part of it, and which is always weird because we talk about in workers' compensation jurisprudence as compensability, but our statute's 440 and specifically 440.09, that section is not called compensability, it's called coverage.
Right.
So we're talking about covered events and what is a covered event. So just generically, right, there's three elements that you have to meet in establishing what we call compensability, but really what's coverage, right? And that is, accidental injury, right? And within all that, there's a lot, right?
There's a lot.
The second is in the course and scope, right? But more importantly, and what we're talking about is this concept of occupational causation, right? And in Florida, again, you have to meet all three of these particular elements in order to have a covered event under our statute. So again, accidental injury arising out of, which is our occupational causation element, and in the course and scope of employment. So let me put it a little differently, right? The employee must typically be performing work that she's supposed to be performing at a time and place, and that the employment in some way contributed to that injury. Am I right with that, or did I just make that up?
No, that's 100% right. And you're right. There is not any commentary about compensability in that statute. So that's an interesting point because at the end of the day, this is insurance. So, all of us can relate to insurance in different aspects of our lives. And obviously coverage is where they're going to be coverage for this particular incident is the key. And this is how we can establish coverage. In my case, I represent injured workers. And so my job is to try to establish coverage for my clients. And Henry is representing the insurance companies. And so he's trying to find ways to deny coverage on these claims.
Well,
just kidding.
Right. So, obviously it's a self-executing statute. And if indeed it's accurate, right, and factually correct that there was an accident arising out of in the course and scope of employment, then, we get past that initial coverage and we go into the benefit stage, which is an entirely different topic.
Yes, and future episodes in these series, we'll be talking about those different types of benefits that an injured worker will be entitled to once they can get past this initial hump of securing coverage, establishing that there's a covered event. So, and today the main focus will be on that one of those three prongs that Henry discussed, which is specifically arising out of. The concept is, did this event that caused an injury arise out of the individual's employment? So that's kind of the focus of today. And, we're going to talk about some cases that apply to this concept.
Well, and it's important that we look at the case law because if you read the statute, it seems pretty straightforward and an easy application to any fact pattern. But as we'll discuss, the different fact patterns that we are presented with on almost an everyday basis can really change the outcome of whether this is a covered or compensable event.
That's right. And so, one of the cases that I always like to start with when I start making analyses on arising out of cases is there's a Florida Supreme Court case from 2004. It's Taylor versus School Board of Broward County. And here the Supreme Court says a great quote, in my opinion anyway. It says, "Let the employer's conduct be flawless in its perfection, and let the employees be abysmal in its clumsiness, rashness, and ineptitude. If the accident arises out of and in the course of employment, the employer receives an award." if you read that, it's trying to almost say exactly what Henry said, which is this should be pretty simple, guys. It doesn't matter how clumsy or how silly the claimant was, where they shouldn't have done or did or didn't do. If you didn't tie your own shoelaces, you'd still be covered. But at the same time, they would still be covered regardless of the circumstance. So this initial case seems to tell us arising out of should be a very simple concept to prove. But we'll talk about some cases right now where that was not exactly the outcome.
Not even close to being simple. So I guess we can start with a bunch of different cases, but what case do you really think we should start with?
I say we talk about Valcourt because I think that's when we saw a major shift happen in these cases. So let's talk about that.
Okay, so why don't you tell us what you think Valcourt said?
Of course you were going to do that. But so Valcourt Williams, right? This came out. This is one of the other wonderful things that came out of the COVID pandemic. And so Valcourt Williams is a case where there was an individual who was working from home. And so now that's become a pretty common occurrence. We now see that working from home is what a lot of us are doing, myself included. And so this individual was working from home.
It's not just any individual.
And that's the best part. I agree with you. And the individual happened to be an insurance claims adjuster.
Right.
So the exact people who will be deciding these cases, for you as an injured worker. And so this individual was working from home, as many of us continued to do and were during the pandemic. And she had gone to get a cup of coffee, right?
Right.
So she had gone into her kitchen to get a cup of coffee. And in the process of doing so, she tripped over her dog.
I thought it was a cat, but maybe it was a dog.
Maybe it was a cat. There was a pet. So she tripped over her pet and suffered injuries, and they were pretty substantial injuries. I believe her hip needed surgery. It was a pretty big to do. And so the concept was, well, I was in the course and scope of employment. If I would have been at my office and gone to get a cup of coffee, I could have tripped there just as easily. So since I was working at the time, this should be a covered event.
Right, personal comfort doctrine, right?
Exactly. So, but what did the court say? They didn't necessarily agree with that.
No, they did not. And the court said that it's not a compensable event. And they talked about, and I think this is the key, if there's a thread between all of these arising out of cases, is the more there is a non-occupational competing cause, right? A non-occupational competing cause that is the major contributing cause, and we'll talk about major contributing cause at another time, of the accident, of the accidental injury, the less likely that that's a covered event, the less likely it's a compensable event. So the dog or the cat or the pet being at the quote-unquote workplace obviously had nothing to do with the employment. It was entirely a non-occupational cause. But this case caused all sorts of consternation.
Yes, this case kind of caused all hell to break loose, at least in the workers' compensation world as far as we're concerned. And it caused a lot of carriers to rely on this to suddenly go, hold on a minute, should we be denying more cases where individuals are performing what would otherwise be considered a mundane or common task in the workplace?
Right, and it's funny because a lot of my clients after this opinion came out and they asked me what this case meant. And, I had to read it a few times because I kind of didn't really know what this case meant. I thought, as many of our lower court judges thought, that this eviscerated the personal comfort doctrine. And it didn't. It didn't. What, again, I think it did was it just restated what had been the law already, that the more it's a non-occupational cause, whether it be a pre-existing condition or a dog, right, the less likely it's related or, occupationally related to or the accident occupationally related to the employment. So I think that was the key distinction in these cases. It didn't do or did not do, to use a double negative, what everyone thought at the time.
But it certainly felt that way for a lot of us who are representing injured workers, and even for those of us who represent insurance carriers, trying to advise them as to how to proceed on these cases was definitely challenging because it left a lot of question marks, which we later found out wasn't really a question mark. Like you said, it just restated what was always there. Right. But for whatever reason, it definitely caused, pandemonium. Right. But
it was like almost a wrong analysis after this case. I was getting questions and suggestion that just because this could have happened anywhere doesn't make it related to the workplace, and that's not accurate. It's not accurate. Then certainly not if you just look at the Taylor case that you mentioned earlier. And again, that language is just, it's amazing. And you see this coming up more and more often when we're talking about these arising out of cases. The injured worker could be clumsy. The injured worker can trip over his or her own feet. And unless there's some non-occupational competing cause, right?
And that's the key. So that really brings us to, I think, where the cases came, what we would call the post-Valcourt-Williams series of cases, for which there were several, because obviously this caused a lot of questions and created a ton of case law and litigation. And so that's what it all kind of comes down to is, is there some sort of external factor? Is there something else that you're bringing into the workplace that's either personal to you or that is literally brought in physically into the workplace?
Right. The dog. Right.
And in some of these other cases, it may be medical conditions that are personal in nature that pre-existed the injury, idiopathic conditions, things of that nature, or pre-existing conditions, obviously. So why don't you talk a little bit about, and pick one of them. There's several. There's Soya, Silberberg. Speak on whichever.
Let me just mention, this is kind of like my own personal commentary on the claimant in the Valcourt-Williams case. I mean, honestly, she could have just said she tripped over her computer cord.
And it certainly would have been a better, resolution for her. But darn it for being honest,
right.
So
but, honesty is certainly the best policy, but certainly doesn't invoke any coverage on the workers' compensation.
No, it does not.
So let's talk about this Soya case, because I think this one's an interesting case because it goes to this whole concept of from the Taylor case, right? And let the employees be abysmal in its clumsiness, rashness, and ineptitude, and the employer can be as perfect as it possibly can be, and yet, right?
There's coverage either way.
Any exertion in the absence of a non-occupational competing cause is work-related. So in Soya,
and say that again, because that's what it all comes down to.
Absolutely,
it's any exertion
in
the absence
of any non-occupational competing cause.
That's the key. That's the whole answer. And
we're kind of simplifying it, right? Because all this really does is it shifts burdens of proof, right? Because if the claimant presents her case and meets all the elements of the accidental injury in an course and scope, and there's no non-occupational competing cause, if it happens at the workplace, any exertion at the workplace, then the claimant's relieved of establishing occupational causation, right? That's the law.
That's the law.
That's the law. And that's been the law for a very long time. All that does is it shifts the burden of persuasion to the employer carrier to show some other competing cause. Now, at the same time, if the employer carrier can show that, then it may preclude coverage. But in Soya was a massage therapist. She was leaving work for the day, walking in footwear that was approved, I guess, by the employer at a normal pace. So she wasn't running, she wasn't skipping, she wasn't doing cartwheels to leave the workplace.
Which I still think, by the way, would be covered events.
Could be.
Just saying. I think, you may want to do-si-do out the door and you're still good.
Rashness and ineptitude, right?
Exactly.
Maybe not the smartest thing to do, but nonetheless. Walking in a normal pace, and she fell and was injured, right? And she didn't know why she fell. The employer even retained an expert to look at the floor. I don't know if it was carpeting or whatever. Found no abnormality. And, the court held, which has been the law even before Valcourt-Williams, that, if a fall's unknown, the causal relationship between the employment and the accident is met. And that's the key. There's no non-occupational competing cause. There's no, and I'll say this again, and sometimes I'm repetitive with purpose. There's no dog. There's no pre-existing condition. There's nothing that the employee imported from their non-occupational life that could be a cause. And I think that's really the way you need to analyze these cases. It's not, this could have happened anywhere. The fact that it happened at the workplace and there's no competing cause, that's it. That's the any exertion. That's the any exertion standard.
Yeah, and what's interesting is the subsequent, so additional and subsequent cases that came out. So there's the Silverberg versus Palm Beach County School
This
Board
is a
case.
great case.
It is a great case. And so, but at the end of the day, what the court states is exactly what is stated in Soya. And it just says it again. And it says, any exertion means any effort in furtherance of the work. That's sufficient. So it's any exertion. It could be the most simple. And here it goes into the mundane exertion of walking to get around work is enough to establish a work cause. And so again, that was the court kind of trying to say, when we said any exertion, we meant any exertion. Don't try to look into this beyond that. The concept of hiring, a floor expert to see if the floor was slippery or not, which they did in Soya, I thought was kind of funny because that's the complete opposite of what workers' compensation is supposed to be.
Right, because it's a no-fault system.
This sounds a lot like negligence to me,
That's
which
right.
guess what? That doesn't apply in the state of Florida for injured workers. And so I found that concept pretty funny. Like the concept of, well, was the floor really slippery and was there a banana peel and was there not? It doesn't matter,
Right.
And it all comes back to the court saying, remember Taylor, remember the Florida Supreme Court said it doesn't matter how clumsy or inept a claimant may be. It doesn't matter how slippery the floor was or was not. Any exertion means any exertion. And absent an outside cause,
Right.
it's compensable.
I think anytime you have one of these cases that hits your desk, right? You whether it be yours or mine, I think the first case you need to pull is the Taylor case, and remind yourself of what we're talking about here. We're talking about a no-fault system. And
I would hope more carriers were doing that. But lately in my cases, I don't know that I agree. But you're right.
No, but I'm not saying that every fact pattern falls, squarely within this stuff. But I think that the first step in any analysis when we're looking at this particular issue is really the Taylor cases, and then the other cases that have come out like Ross, Caputo, and Walker. I mean, those were always the three cases that I looked at when I had these quote unquote unexplained accidents, right? These idiopathic type falls that really no one knows what happened.
Yep.
But we can talk about other variations of how a carrier can unfortunately trip into some sort of coverage if there's increased hazard. But that expands kind of what we're talking about here. But the Silverberg case, wasn't that the case? The teacher that was sitting on his foot or his leg, and then the leg fell asleep or something like that.
Yes, that was it. And there was an unexplained reason for which it became numb. And it all came down to this concept of if you can't provide evidence, the key is evidence. Like you said, it's burden of proof. That's what the real conversation is if the claimant says, I was injured in the course and scope of employment and proves all of their required prongs to secure coverage or secure a covered event, then the burden flips onto the employer carrier to essentially show evidence that there is an outside cause, such as that maybe that person suffered from a medical condition that would cause
some kind of vascular condition or something that's
neuropathy, something along those lines. But absent of any evidence of that, then the court has to rule consistent with the law.
So what about this Alvaro versus Watermark Retirement Communities case?
Yeah, so just, as proof of the fact that these continue to be hot topics and continue to be hotly litigated cases, this ruling came out December 21st of 2022. We're talking, a month ago, basically, a month and a few weeks ago. And here, this was an individual who fell while he was exiting or she was exiting the break room. They were on a break, fell down walking out of the break room, coming back onto the job site, and the claimant didn't know why she fell or what caused her to fall. So this sounds eerily like every case we've just talked about, and yet the insurance company did deny benefits on that case, and litigation ensued till finally there was an appellate court ruling just recently, which we talked about, where the court once again said, hey guys, remember when I said it last time? So I'm going to go ahead and just say it again. Any exertion is any exertion. And unless you, the employer carrier, prove that there's some sort of outside reason for this, then any exertion is any exertion.
Right. And the way I like to frame it for not only for myself, but for the clients that I consult on this point, it's any non-occupational competing cause, right? The dog, the pre-existing condition, whatever it is. I think that's the correct analysis when you're looking at these cases, because again, the any exertion thing is a killer for coverage for the employer carrier in a lot of these cases because, again, go back to the Taylor case. I mean, it spells it out.
And I mean, definitely this will lead to future episodes where we're going to be talking about how this applies in the setting of personal comfort doctrine, which is, it's huge. That's a big, hot area right now. There's tons of litigation that is happening, and it is continuing to happen because, well, they were on their break, and had they finished their break? Were they back working? Were they on a smoking break? Were they outside the building? There's so many small minutia that can, make changes in this law. So I'm hopeful that we can all look back at Taylor and always remind ourselves that any exertion, claimant is covered if they're on the job and in the course and scope. But it'll be, we'll see.
But I do think that there's value in the Valcor Williams, Soya, Silberg, and the other cases that have come out, because I think that obviously there was some question, at least on the side of industry, as to what should be covered and what should not be covered when we're dealing with these unexplained or unknown falls. So I think that at the end, what we're looking for is clarity in what the law is. That way, because it is a self-executing statute, and we shouldn't just be resisting benefits because it could have happened somewhere else. But the idea here is to ensure that we do the proper analysis, and at the end ensure that the benefits that are timely most of the time. Timely placed into the injured workers.
And this is like the typical politician response to everything, but everything is very fact specific.
Well, I mean, all these cases are, aren't they?
All of them, right? So,
right, Valcor, like I said.
Valcor, if she was working at a vet, well, she could have said, but what if she worked at a veterinarian
I was thinking
office?
The same thing.
What if, I worked at a law firm where one of my partners would frequently bring in their pet, and it was like kind of our office mascot, and it was like a, lighthearted, fun thing. So if I was injured on the job and tripped over my pet at home, would that have been a compensable incident? Because
that's a good question.
My typical job setting included a dog, So I think that facts are important in every single case. And right now we're only speaking in terms of generalizations from what we've learned and read and gleaned from reading these cases. And we're giving our opinions at the end of the day, although we're basing it on, the exact verbiage that's coming from these cases that we're talking about.
Mm-hmm.
So I think for today's episode, we've kind of covered what we wanted to cover in terms of the arising out of continuing conundrum. So I have a feeling we'll probably talk about arising out of again, because there's still quite a bit of cases in litigation on this question.
Definitely stay tuned, because there may be some additional refinement depending on the type of cases that are in the pipeline, so to speak, both Definitely. At the trial and at the appellate level.
I've got one myself, so I'll keep you posted.
All right. Well, that was fun.
It was fun.
It's so nice to see you.
Likewise.
I don't see you that often.
That's true, actually. This is an excuse for people to see each other, I guess, now that everything is Zoom, right? A lot of us don't get to see each other very often.
I actually took a shower today.
Wow. I was wondering why it smelled so clean in here. I'm hopeful that at the workers' comp section meeting for the Broward County Bar, that's at the end of the month of
February 24th.
February 24th, Friday, February 24th.
If you haven't registered,
if you didn't register, it's an excuse to come and smell Henry. He smells fabulous.
Yeah,
so
definitely.
That's a reason.
We've got a great presentation. I think you can take a look at the agenda on the bar
at the browardbar.org website, at their calendar. It's a great agenda, actually, and there's going to be a really detailed case law update, so you're going to be able to hear about so much more than what we've been able to go into today.
All right, so that's all for today's episode, right?
Yep, that's it.
What are we calling this? Workplace Matters?
Workplace Matters.
All right, so we hope that this discussion sheds some light on this really important and evolving topic. So anything else you want to say?
No, I guess just a kind of a brief statement we'd like to give about, you can do that if you'd like.
Sure. So if you or someone has sustained a workplace accident in Florida, or if you're an employer who's had an employee suffer an on-the-job injury, it's critical to understand your rights and obligations under the workers' compensation system. It's complicated. It's highly technical. You may want to visit the Florida Division of Workers' Compensation website, or consult with a lawyer who's a specialist in this area of laws. I think it's really, really important that you are given some guidance as you navigate through our our workers' compensation system.
So thanks again, everyone.
Thank
We
you.
hope you'll see us again if this goes well. Please comment. Let us know when you watch our video if there's something you'd like to hear next time or a topic that would be of interest to you and to our community as workers' comp attorneys. And we'll see you next time.
Take care.